repudiates and rejects the applicability of this strange doctrine from foreign jurisdictions far removed from our particular circumstances. In his opening address, the learned Solicitor General, Mr. Kennedy Ogeto, took the view that the Constitution has no place for the doctrine and all its provisions are amendable in accordance with clearly set out procedures for various aspects of it. The Constitution has no eternity clauses, and Kenyans consciously avoided the basic structure by making no mention of it. They struck a proper balance between hyperamendability and rigidity by including Chapter 16, which entrenched provisions with special amendment procedures. That theme was taken up by Mr. Oraro, learned senior counsel, who posited that unamendable or eternity clauses cannot be recognized unless they are stated expressly in the Constitution. When pressed to point out where the doctrine was rejected, where exactly it was rejected in the report by the committee of experts, he responded, apparently without irony, that entrenchment was implicitly rejected. Answering another question about Colombia, he said that the Colombian case was an outlier and it is a divided country and we should not follow its example by acknowledging an implicit existence of a basic structure and unamendability in our own constitution. He next made the submission that the case at bar was the first time the basic structure doctrine was applied in our jurisdiction. It had been adopted by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere and it is inconceivable that we can introduce it in Kenya. Mr. Oraro was emphatic that our Constitution provides for its alteration and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, learned counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yash Palgai and Jill Cottrell, Alicia Vernon, and James Gadhi, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution lest the spirit of the Constitution should create a legal theology. Dr. Otiende Amolo, senior counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned senior counsel asserted that even then, the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned senior counsel Professor Bbi Verdict still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists and brought by people who have standing. To entertain such grievances and make such orders at large leads to an erosion of the dignity and sanctity of the court. And then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyon, the learned counsel for the National Assembly, also urged rejection of the doctrine, but in the present case, he considered, as he had to, that 74 amendments proposed in the Bbi bill were numerous. He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel, Mr. Job Wambulwa, was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiku's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga, Land Council Mr. Ndegwa Njiru was equally opposed to the doctrine. And returning, he made reference to the Kivuitu, Priscilla Ndululu, Kivuitu and another versus the Attorney General. And he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subject to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as Land Counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the Bbi proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit and that changes to that core structure can only be effected through the exercise of constituent power with 4 features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, Council made reference to John Locke's 2 treatises of government and Baron de Montesquieu's The Spirit of the Laws to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which though not spelled out in the constitutional text are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the Independence Constitution. He pointed out that Justice Ringera had acknowledged that, but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate, successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Rosnai, Council warned of the dangers of populist constitutionalism characterized by constitutional capture. He also refers to Dr. Mutaha Kangu's Constitutional Law of Kenya on Devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued in favor of the doctrine, adding that courts bear more than obligation to defend the Constitution as they are invested with the authority to defend it. He made a distinction between amendment and repeal by making reference to Black's Law Dictionary. So stating, he posited that the BBA initiative and Constitution Amendment Bill was an attempt to repeal the 2010 Constitution by implication. This is impermissible because the said Constitution is for eternity, which he explained to mean, quote, for as long as we have it. Next came Professor Kidure Kindiki Learned Counsel, who posited that there is a hierarchy of constitutional norms. And to demonstrate the basic structure, he posed the question whether one can amend the Constitution to change Kenya from a multi-party democracy into a constitutional monarchy, or alter its territory by having a part of it donated to another state, as had happened elsewhere in history. To him, such fundamental changes require a direct involvement of the people. He went on to say that the judges did not say that the basic structure cannot be altered, as the complaining appellant seemed to project, but rather that such changes must be subject to a deeper process involving the sovereignty of the people. He went on, indeed, appealing to us to dismissed the appeals with costs. He turned all spiritual, submitting that the BBI process was a botched attempt to overthrow the people and the